Hello, everybody, and welcome to the Crimson Presents Surviving a Pandemic, My Business, My Job, My Security. It has been an absolute heartbreak for so many of us, not being able to go to work, of course, because of the pandemic, and staying at home all these weeks, which have just been extended from the initial 21 days, and now we've got another 2 weeks added, staying at home. Having, of course, gone through the normal, this now seems to be the new normal, where most people are working from home, except, of course, for the essential services. My name is Maimba. I'll be moderating this conversation today. We have got four amazing panelists that are with us this evening. And thank you to each one of you who took time to register and be a part of this broadcast, be a part of this conversation, which is very, very critical and very, very important. We are going to be going through, it's a three-part series, so it's very important, it's very imperative that you plug into the first one. The first one will lead you into the second presentation, and then the second presentation will lead you into the third presentation on Friday. So we've got today, Monday, 5:30 pronto, like we've done today. And then we've got 22 on the 22nd of April. And then the last of the three-part series is on the 24th. And we really hope that you'll be able to tell one and tell everybody about these conversations. The first one, of course, today, which has brought all of us together, I am told by our team that we've got about a good number of you that have come through and plugged in. Day one, COVID-19. What does this mean for your employment contract? What does this mean working from home? Do you still have those benefits? Are you entitled to those benefits? I mean, it already looks like you're on holiday, right? So we want to find out from the legal perspective what this means. Do you get a full salary, as it were? You know, these are conversations that we're going to have. So we've got for every presentation, we've got an expert in the field that's going to come in and give us a presentation, and then thereafter you guys have got a chance to bring in your questions, and we're going to be taking them from there. And in terms of our panelists today, in terms of our lead presenter, of course, is Victor Nkomo, who is our guest speaker. He is a legal guru, a legal expert. He's a legal practitioner with 10 years experience as a magistrate and over 20 years experience as a human resources practitioner. He's past chairman of MCO's Labor Committee and past president of IPMZ. He also loves blogging on issues of labor law matters in his free time. So Victor is our lead presenter today. We've got, of course, part of the panel. We've got Dr. Godfrey Kanyenze. We've got Rose Namo, and we've got Noreen. I'll give you their bios in the next couple of, when they get to make their own presentations. But today we are focusing on Victor's presentation. Without much further ado, allow me to hand you over to Victor, so he can give us, shed a little bit of light on the legal side of this whole COVID-19. Victor, please come through. Welcome.
Maimba, thank you very much. Thank you very much for that introduction. I reckon the first thing is to greet our participants. I hope you're all keeping well wherever you are in the current circumstances. My role is very simple, and I have a very short period of time in which to speak with you this evening. I literally 15 minutes. I hope I can cover as much ground as possible. And obviously expect that my fellow panelists will be coming in as well to plug in some holes that I might have left or make some additions, etc. But the first and most important thing in my view is we need to define the problem. Why are we all sitting here? What are we looking for? I think we're looking for an answer. And essentially what is happening is, I assume that the majority of our audience today is HR practitioners who have this peculiar problem that you want to go to work, but you can't. The employer wants to give you some work, but they can't, unless obviously you're essential services or in manufacturing starting today. So the issue is you are trying now to say, okay, what do we do with the conditions of service, remuneration in particular? The staff are away from work, on what basis are they, on what terms? And you're looking at your normal sources of the law, and yeah, you are not finding the answer. I think that basically is the problem. And what I would like us to do very quickly is to go through our normal sources of the law that we would look at, and then say which ones are likely to help us as we resolve this issue. And I would like to close ultimately by saying what are the key learning points that come out of this presentation. Simu, you are in charge of my presentation somewhere. I'm presently seeing the poll. Would you want to bring up the presentation, please? Thank you very much. Yeah. So the instruments that would normally guide us as HR practitioners when we look out to resolve issues in our workplace are guided mainly by Section 65 of the Constitution. That is the fundamental law of the land, and anything that is in conflict with the provisions of the Constitution becomes invalid to the extent of the inconsistency. So we need to be very much au fait with the provisions, in particular, of Section 65 of the Zimbabwe Constitution. And essentially, you are there talking about fair, safe labor standards, just equitable and satisfactory conditions of work. And how these get to be applied is difficult because the Constitution does not spell out, and things then get spelled out in some way by the Labor Act, which actually informs us that conditions of service are set at NEC, Part 10 of the Labor Act. It also provides for works councils to set conditions of service. And you also have contracts of employment that are not governed by either NEC or Works Council. These are your senior staff. So those guys, you governed by the Act, you governed by the Constitution, but the NEC and the Works Councils do not govern those particular ones. The one thing that came into effect very recently, as we were about to go into lockdown, was the national minimum wage, in terms of which the minister set the national minimum wage at $2,549.74. So we're saying to ourselves, here we are getting stuck with a new minimum wage set at national level, which we really don't have much ground for trying to set aside or get an exemption on. And it's coming at a time when we're not able to work and deliver to our customers the way we would normally do. So these are the instruments that we would look at normally, and if you like, you can add to that decided case law, because that also helps to explain the provisions that we've been looking at. Can we go to the next slide, please, Simo? Okay. As we go into that next slide, I think we do need to speak. I've spoken about case law, which is certainly authority, which we would look at in order to find solutions to the problems that we have today. But there is also the fundamental thing, which is common law. And we'll come to that in the penultimate slide. Now, what is new so far as our labor relations is concerned since the beginning of lockdown is the minister's press statement of the 10th of April. And essentially what the minister has done is to draw our attention once again to emphasize the importance of the provisions of the Constitution. He mentioned particularly Section 65. He also mentioned Section 2A of the Labor Act, which really are broad guidelines that tell us how we should interact and operate in terms of our labor relations within the workplace. And the summary of all that is there has to be social dialogue, because if you go to any of the instruments that I've mentioned, you will not be able to find a solution to your problem, which is how do you treat staff when they are away from work for no fault of their own, or how do you treat an employer who for no fault of their own is not able to provide work to his staff. So what's going to happen? So essentially, we basically being taken back to social dialogue. We will have to talk and agree among ourselves in our separate workplaces in terms of how we should proceed. But we ought to be guided by those overarching provisions of Section 65, Section 2A of the Labour Act. Now, the other important thing I need to talk about is the fact that the minister has said, please, as employers, refrain from imposing unpaid leave, retrenchment, unfair determinations during the lockdown period. And I think lastly, one should say on that, the minister indicated that there is some dialogue going on regarding workplace guidelines. Workplace guidelines regarding COVID-19, lockdown, I reckon, and related issues. It's very important for us to, before we leave this slide, to emphasize the fact that what the minister has done, apart from referring us to the existing provisions of the law, what the minister has done is to give us what we could call persuasive government policy, which definitely is not law. But I would say it's very highly persuasive on the basis that it is based on the provisions of the law as it stands today. So that's the importance of that policy statement by the minister. Can we go to the next slide, please? Right. So I wish to emphasize this, because what has happened is most of the employers have actually taken positions regarding what will happen with regards to the type of absence that the employee will experience during lockdown, and also what will happen to remuneration issues during lockdown. One really ought to say these issues are not going to start and end with the lockdown. These issues are going to spill over, because it's highly unlikely that we will get to the situation as we always knew it post-COVID. Clearly, that workplace will change. When you go as an organization for 5 weeks without revenue, how are you able to carry on thereafter? What is the position with your customers thereafter, etc., etc.? So there will be a new normal, definitely, after COVID. And so these issues are likely to spill over. And as some social commentators will say, the new normal will never again be the same as the normal we have known prior to COVID. So the critical issue I want to say here is, and emphasize, is that the law as it stands now, or as it stood on the 30th of March when we went into lockdown, has not changed. There isn't additional new provisions of the law. As a consequence, whatever decisions we take will have to be within the provisions of the law. So the issues that we are grappling with will be around remuneration. Are you going to get your full remuneration as employee? Are you going to get part of it? So what's your absence from work? What is the nature of your absence from work? Is it leave? Is it sick leave? What is it? You cannot find it in the provisions, in the precise provisions of the law. And if you're going to utilize the present provisions of the law, you will obviously be talking about either paying the salary in full, or you're talking about paying a part of the salary and getting the staff to flog some of their leave days, getting cash in lieu of leave. You might ask some who might fall sick to utilize the sick leave provisions. And I know some employers have gone and said it is unpaid leave because we do not have revenue for the period of April through to the end of lockdown. And some employers I'm sure we've seen on social media, some employers are already giving notification of termination of employment, and others are already negotiating with their staff some kind of sabbatical. You know, I think at the end of the day, the fact of the matter is we will not, whether as employers or as employees, be able to get away with anything that is not within the four corners of the law. And we will still have to treat all our problems in terms of the law as it stands, unsuitable as the law may be. That is the point I need to draw your attention to on this slide. You cannot just walk away from your responsibilities. In as much as you underwent due process coming into your responsibilities, you have to, again, utilize certain due process as you walk away from it. What I see is that what the law does not provide for, as it stands now, are issues of substance, substantive issues. For example, what am I supposed to pay my employee when my employee has not come to work for no fault of their own? What leave of absence, what nature of leave of absence should my employer give me when I'm away from work for no fault of my own? You know, so these are the substantive questions that you will not be able to find in the law. However, the procedural aspects of the problems that we face are covered by the law. How do we go about doing it? So whether you are retrenching or you are paying half a salary, or you well, if you are paying a full salary, happy days, happy days. But if you are not, then you need to follow the procedural guidelines of the law. Those are in existence and they require us to comply with them. Okay, next slide, Disemo. So, because there is substantive issues we are not able to find answers to within the law, the regulations in terms of statute law, be it the Constitution or the Labor Act, we then tend to look at common law. What does the common law provide in these circumstances? And the provision or you know, the statement of common law that comes very quickly to many people now is supervening impossibility, which really is a reference to a natural superior force or an act of the state. And in this instance, we have a combination of the two. Natural superior force in the sense of COVID, and an act of the state in the sense of lockdown. These make it impossible for you to operate your contracts of employment the way you have always done. And because you will not find the answer in statute law and in common law, you will then go back to discourse at the workplace. You will have to talk and say, guys, these are our circumstances. What is our way forward? So, the question of supervening impossibility, as outlined in the case that I've cited on that slide, is saying the supervening impossibility will not necessarily release you from your obligations 100%. So if it's a temporary case of impossibility, you might have your obligation merely postponed as opposed to being taken away altogether. But obviously, if you then shut down at the end of lockdown as a business, then the level of impossibility has become final, and therefore we're talking about you being unable completely to comply with your obligations in terms of your employment contract. So in closing, what I would like to say is the issues that we learn, I think, from this presentation in summary are, I timed myself here for 15 minutes, which is exactly what is happening. So guys, the law has not changed. We still have to find the solutions to our problem within the law. That is the first thing. The decisions we will make will not be made in a vacuum or in a whimsical way, the way we want to, whether as an employer or employee or trade union or employers association. We will have to come back and sit down together in our respective workplaces, NECs and that, and come up with decisions that will help us to resolve the impasse we face owing to COVID-19 and lockdown. And like I said, I think we need to be aware that there is substantive issues that we are not able to find answers to in the law. However, in terms of procedure, the due process that we need to follow is contained squarely in our law as it stands today. Ladies and gentlemen, I hope that helps. Maimba, back to you. We can't hear you, Maimba.
I hope you can hear me now, Victor.
Absolutely,
and everybody
absolutely.
else. Thank you. I was just saying thank you so much for your very incisive presentation on the legal implications, of course, and to all of the participants, everybody that is plugged in. Again, allow me to say thank you for coming through and for plugging in. The team tells me we've got about 100 participants that have registered to have this conversation that is very, very critical and very, very important. We have not gone this way before. We've not been this way before in terms of the pandemic that has literally changed the world over, everywhere in the world, changed the way we live, changed the way we work. And today we're looking at the legal implications. Do you get more leave days? Somebody, I don't know if any of you read a joke that somebody's going to take a 3 months leave. After all this pandemic, somebody's going to decide to file in papers for 3 months leave. I mean, there's got to be that legend out there. There's just one legendary man or woman who's probably, I don't know if that's going to be Rose, but we'll see what happens. And of course, this conversation, it's very, very important that we acknowledge Primson Management Services, a consultancy that spread itself in Zimbabwe, Zambia, and Botswana, offering consultancy services that I will go through later in this program, so that we have a little bit of knowledge as to who they are. And of course, we also have got EduDynamics. EduDynamics, we've got Distinctive. These names are really, really cutting edge for me. Oh yeah, I just said cutting edge solutions there. And of course, we've got, like I said, in terms of the panel, we've got Rose Namo, we've got Noreen, Winnie Dari, and Godfrey Kanyenze. Thank you very much, guys. I will start with you, the lady, Rose. Just a response to Victor's presentation, then I'll go to Godfrey. And then I want to say to everybody else who's plugged in as participants, please, this conversation is for you guys. Plug in. We would love to have your questions. Please ask any questions that you've got pertaining to Victor's presentation, or if you have any legal questions, what has been happening at your workplace? Do you think that you've been treated unfairly? Do you think that they've changed the laws on you? Please send in those questions, comments through the chat box, and we'll be able to respond to you. Our panel will respond to you. Thank you. We've just run our first panel, our first poll. We'll be looking at the results. The question was, do you believe that COVID-19 and lockdown have brought about changes to our labor law in Zimbabwe? 67% of you guys said definitely. 7% said not at all. And 26% said not sure. So we're going to be running our next poll just now. And our next poll is, can I give the question out now? And then we go to the responses. Okay, our next point is, what is the best way to help employers and employees to resolve labor issues during COVID-19? Is it change the law to suit the environment? Is it let the parties have dialogue? Victor spoke about social dialogue, and I have no idea, which, by the way, is perfectly fine. Please just participate in the poll, and we'll announce the results later. Over to you, Rose.
Okay, thank you very much, Maimba. I'll just do a very quick comment on what Victor has said. Thank you very much for that presentation, Victor. The key issue for me is that there can be something which is legally correct, but the way it is implemented can be morally wrong. So the advice that I'm giving, or just adding on to what Vita has said, he emphasized the issue of due process. So what is very important is that whatever decision that the organization has made, they've got a plethora of legal issues that they can follow. It can be short time, it can be retrenchments and so forth, as what Victor has said. But what becomes very important is the how you do it. So you will find that if people are abrupt or organizations are abrupt about how they go about implementing this, this can take away whatever mitigatory issues that have come up as a result. So one of the most important things is to ensure that, yes, whatever it is that we do is legal, but we follow due process. And also, for instance, I'll give you an example. We keep seeing on social media a number of letters from various companies that are going to staff. I always ask myself sometimes, have employees been communicated to first, or they sometimes see these letters on social media, for instance. So it goes to the how of how you actually implement a legal process, which is your due right as an employer, but the how is actually very important. And it's also very important to appreciate the fact that Victor has said that whatever it is that we do as employers should not be unilateral. It should be a process, and there should be consultation. One of the things that a lot of employers are saying, some of them are saying, we had 2 days to prepare for this, and we didn't see it coming, or some saw it coming, but our employees are all over the place, and we are not able to communicate with them and so forth. Yes, that is the case, but we have to give due recognition to the fact that the process is just as important as the outcome. Thank you very much.
Thank you very much, Rose. The process is important as the outcome. Thank you very much. Dr. Kanyenze, your response to this, and again, allow me to say to every participant plugged in, please send in your questions. We already have a couple of questions that have come through, and our panel of experts will be able to respond to you. Dr. Kanyenze.
Thanks very much, Maimba, and also thanks to Victor for a very, very clear and lucid presentation. What is very clear from the presentation is the fact that these are extraordinary times. The law does not deal with these issues in a comprehensive manner, as he has rightly pointed out that there are quite a lot of substantive issues that cannot be found in the law. But however, what is very critical from Victor's presentation is a word that or a principle that informs our current labor law that is so critical in addressing and dealing with crisis episodes like what we're going through, the issue of social dialogue. I think he emphasized and underlined that there has to be social dialogue at all levels. I think this is very, very important. What this therefore implies is that if you are an employer and you haven't really invested in good industrial relations, you will find it very difficult to deal with the issues. If you have invested in good industrial relations and you have inculcated a culture of social dialogue, you really reap the benefits because there will be trust, and you can actually share the way forward with your employees without being unilateral, as Rose has highlighted. What is also very critical that Victor did not highlight is that this is not a pandemic that is isolated to Zimbabwe. It's a global epidemic. So we can also learn from what is happening elsewhere. For instance, Zimbabwe is also part of the global network. We are part of the International Labour Organization, for instance, and they've come up with a recommendation to assist governments under such conditions. In fact, this recommendation was adopted in 2017 following the Ebola outbreak in Guinea, Liberia, and Sierra Leone, if you remember. And the issues are very, very similar in the sense that the devastating impact on the economies. And hence they came up with this employment and decent work for peace and resilience framework, which they are now using as guidelines to deal even with the COVID pandemic in terms of how governments can come in. What I also liked lightly from Victor's presentation is when he highlighted that there are two sources of the challenge, namely the supervening natural superior force and the act of the state. So the public sector becomes very critical under such conditions. And that's why you see in a lot of countries, because employers may be finding it very difficult, they're in distress, they may not have the capacity to pay salaries, or, for example, to implement a moratorium on retrenchments, governments then come in with emergency relief measures. We've seen this in South Africa, we've seen this in Botswana, where governments have set aside resources or relief funds to assist companies to stabilize under such conditions, and also to ensure that employees receive their salaries. So these are some of the critical issues that we need to underline. Dialogue, 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 whether it's at national level. In Zimbabwe, fortunately, we now have the TNF, the Tripartite Negotiating Forum, has now been enacted as a statutory body, and that's where we need to meet. And on Thursday last week, the TNF met to discuss some of the mechanisms that can be implemented to address this crisis. So thanks very much.
Well, thank you very much, Dr. Kanyeza, there for your response. As you were talking there, I had a moment where I scratched my face, you know, and I want to take this opportunity to tell everybody, please stay safe, keep your hands away from your face, your nose, your lips, and make sure that this time of the pandemic, every one of us is taking care of each other and taking care of your loved ones. Now, thank you very much. Thank you, of course, to Victor, who was our lead presenter. Thanks to Rose. Thank you to you, Godfrey, for your responses. And like I said, it's very important for this program to take as many questions as we can from the guys that are plugged in, because this is what they're plugged in for. I'm going to be reading a couple of questions which are very legal. If any of you guys, Rose and Doc want to chip in, you can chip in. But Victor, I hope you've got these questions as well. The first question is coming from Rudo Stephanie Nwe, and Rudo says, can employers lawfully pay partial remuneration, and how? All right. Can employers lawfully pay partial remuneration, and how? That's Rudo Stephanie Nwe. I'm going to take 3 questions at a time. 3 questions, and we get responses. 3 questions, and according to my time, it's 6:02. We've got about 28 minutes to go. This is an hour's presentation, so it's very important that we start on time, we finish on time, and we try to do everything professionally, so that, you know, we keep getting the numbers coming in. And then Shamaine Ndlovu says, so are we saying employers must pay salaries, be it in full or partial? And that if it's partial, they back pay when lockdown is lifted. They back pay when lockdown is lifted. And then the third question from Shorai Chidemo, she says, can an employer unilaterally decide to make the employees take this period as their annual leave? Man, even I can answer this one, but I'm just joking. Can an employer unilaterally decide to make the employees take this period as the annual leave, meaning that the employees still get paid, but when the lockdown is over, the employees won't be able to take their annual leave? So is there a swap deal there? You know, take this as annual leave, and then when the lockdown is over, you don't have leave anymore. So those are the 3 questions. And as Victor and the team are getting their answers in order, can I go back to the poll? The poll results for the second poll. The question was, what is the best way to help employers and employees to resolve labor issues during COVID-19? What is the best way to help employers and employees resolve their labor issues during COVID-19? 28% said change the law to suit the environment. And then 72% said let the parties have dialogue. Let the parties have dialogue. And then 0% said I have no idea, which I am not surprised, you know. I have no idea. So those are the results for our second poll. Thank you so much for everyone for participating. It's so important that we we participate. So the three questions. The first one, Victor, are you coming in with that one?
Yeah. So, member, thank you. After looking at, and thanks for giving us that opportunity to put our minds in order as you were dealing with the poor. Looking at the three questions, we have one question. We have really one question. What can an employer do and do properly and legally in the current circumstances, so far as remuneration of staff is concerned? And the gist of the presentation this evening was this. If you go and look whether at the Constitution, at the Labour Act, at your NEC and Works Council collective bargaining agreements, you can even go to your employment contracts and over to the to precedent law, which is your cases. You will not find the answer because it's not provided for. The law has not actually foreseen and provided for this. So this is why the minister and I think the presentation by Dr. Kanyenze there was very critical. There is the issue of social dialogue. You have to go back and have the social dialogue in terms of how you're going to proceed and remunerate staff during this period. And the critical issue is this. You will either resolve these issues through dialogue with the employees who are not covered by both NEC and Works Council. Those who are covered by those two bodies, you will have to go through the process. You cannot just go and do it unilaterally or impose it on your staff. You will have to get it right. And at this moment, I would like to say this, which I did not say during the presentation. You know, we will get back to work. COVID-19, the storm is going to end, and some people will be without employment. And if you have not done things procedurally and according to the law, whatever you've done becomes null and void. I think everyone will understand an employer who will say, while I was not able to meet with my employers and discuss the way forward, I decided I would do this in the interim, but then you need to go back and get that ratified through dialogue. And if it's NEC staff, you need to get that issue ratified by way of application to the NEC, assuming that you did not pay the full salary. So those things are very, that dialogue is very, very important because essentially you are finding yourself in very unique circumstances. So my answer in simple, in short, you will not find the answer in the law in terms of in these circumstances. Like for example, when your employee is sick, you go to the law and you'll find sick leave provisions. When your employee wants to take a break, you go to the law and you'll find vacation leave provided for. You will not find the answer in the statute or in the case law. You will not find it. So you will need to go in dialogue. However, the law provides for the due process that you need to follow in order for you to legitimize the decisions you may have taken unilaterally as you went into lockdown. Those are that would be my answer in summary. I hope it helps.
Well, thank you very much, there, Victor. And the second and third.
I think essentially this is why I remember I said I'm rolling these into one because they essentially
all right.
Yeah.
Okay, cool. Thank you, Victor. Allow me, guys. I've got a lot of questions that are coming in. It looks like this is a very emotive and a very hot topic. Maybe I could read a comment. This doesn't look like a question, but it is a comment from Wellington Magaya. Wellington Magaya is a guy that I know. He's a legal practitioner, and he says, my take is that nothing has changed, and employers must find commercially sensible solutions. Reliance on supervening impossibility and force majeure is not going to be easy. An employer must be able to demonstrate that it is impossible to pay salaries. That's not easy when you have only not traded for 30 days, yet in your previous year you made 600% profit. Okay, so that's Wellington's comment where he's saying in the previous year you're posting profits. You can't then wake up and say we didn't make a profit. We didn't make a profit in 1 month. You know, that's a comment from Wellington. But I will now, a question from Marjorie Zondo. What happens in a situation where you have someone on probation? Do you extend the probation, or it ends when it was supposed to end? How do you effectively evaluate someone on probation who is now working from home? Okay, somebody just joined the company, they're on probation. I think that's a clear question. Thank you, Marjorie Zondo. Thank you, Wellington Magaya, for your comment. And then the third one there is, this is from Vezokuhle Sibanda. I hope I said that correct. Vezokuhle Sibanda says, regarding remunerations, is there anywhere where an organization can get assistance if they are unable to pay their employees? Regarding your remunerations, is there anywhere where an organization can get assistance if they are unable to pay their employees? And then maybe the last question, so that you guys can respond to this next batch, is, are we still obliged, this is from Charmaine Bosch, are we still obliged to pay allowances like transport and cell-phone allowance, even though our staff are not coming to work or making work calls? And I thought we were working from home. How is a person not making a work call if they're working from home? All right, I will still obliged to pay allowances like transport and cell-phone allowance, even though our staff are not coming to work or making work calls. Now, as our panel are getting ready to answer these questions, allow me once again to each one of you, thank you so much for plugging in and being a part of this very important conversation. Today, our lead presenter is Victor Nkomo, and he just took us through a very incisive, informative conversation. And we have got Rose here, we have got Dr. Kanyenze, who are going to go through and just give us their thoughts. And of course, Victor, any one of you guys, the question that I've put across, should I go back to Victor? Did I come to you, Rose? Victor is back on the screen. Thank you. Godfrey, Victor. Today's okay. Your day, Victor. Today's your day.
So thanks, and thanks to Wellington there. That sounds like my lawyer. I think we've done a few labor cases together. That sounds like my lawyer. So to start with probation, I think the first critical point is this: the law provides for one term of probation of not more than 3 months, which cannot be extended. That is the law as it stands today. Point number one. Point number two, I do not believe that the fact of the absence of the employee from the office must then completely disable the employer to objectively evaluate the capability of that employee. My view would be, you still have means of evaluating the performance of the individual, unless they are doing that kind of work where they can't at all work from home. So my view would be worried about extending the probation, because the law as it stands does not provide, it specifically forbids the extension of probation. And secondly, try and explore the feasibility of doing an evaluation of the employee while they were present at work and while they were working from home. Hopefully they were working from home. I have no answer absolutely, and I would ask my colleagues to assist me so far as if the employee is not capable of working from home. But there's also an issue of, as the 30th of March struck, where on the 3 months probation was the employee? Was it 2 months? Was it 3 months, etc.? So a lot will also depend on the facts of a particular case. In terms of, can employers get assistance anywhere else? Not that I'm aware of. I think I've indicated elsewhere where I've written on this to say, and I think Dr. Kanyenze ably drew our attention to what other countries have done. In South Africa, they clearly have gone to their unemployment insurance fund, and they're drawing out of that to assist employers to pay salaries during this period. We do not have a similar facility in the country. So that's as much as we can say. I will defer to Godfrey and others so far as that goes. And is the employer obliged to pay allowances like transport, for example, etc.? My first port of call would not be the law, but rather the collective bargaining agreement that brought the allowances into existence. Because these allowances are normally paid for a purpose. I would say start with your collective bargaining agreement, or if the employee is not covered by a collective bargaining agreement, go back to your employment contract and look at the terms upon which this allowance was extended. So that should give you the guide. If it is not there, my view would be normally you pay, and you really separate these allowances from your basic pay. So they are paid for a specific purpose, for you to come to work. So one would ask, when your employees are on leave, for example, what do you do? These are some of the issues you need to look at. Do you normally pay transport allowance, cell phone allowance, etc., when your employee is on annual leave and they are not coming to work? So that issue again of practice comes into effect. So I'm hoping that I'm giving adequate leads in terms of the things that you need to look at. And at the end of the day, we need again to just give this warning. Do not take it from this webinar to say they said this is the position and therefore that is the position of the law. No, we are here just a kind of brainstorming.
Is that a disclaimer? Is that a disclaimer?
It's a disclaimer. It's a disclaimer. but I think more usefully to say,
yeah,
each case will depend. Each case will depend on its merits. Go look at the CPA. Go look at the contract of employment. Go look at your practice. What is your past practice? This should give you some lead, but ultimately, you might end up at the table discussing that.
Thank you, Victor. I've got a lot of questions that I really want to take. Unless if Rose and Godfrey have got something to say, but I quickly want to go. If I can go to more questions that are coming. Victor, you're on the hot spot. Rose, you want to say something?
What I just wanted to say is that Victor's answers are actually telling us something very important, especially as HR practitioners. The way we word our contracts and just appreciation of how certain benefits come to be. So for instance, if someone has got a company vehicle and it's clearly articulated that is for you to come to work and for limited personal use, for instance, and then you are not coming to work, you are working from home, you are able to play around based on the wording of the contracts. And I also want to just talk about the issue of social dialogue comes back again, because we cannot have our cake and eat it too. So everyone has to make some kind of compromise in as far as all these issues are concerned. So for instance, allowances, etc. If you had good social dialogue with your employees, you'll be so shocked that the employees would actually be willing to drop some of these things because they know that I was being given transport allowance to come to work, but right now I'm working from home, but you can then compromise on the phone calls and things like that. So it's very important that we appreciate those facts. Thank you very much, Maimba.
Thank you, Rose. Thank you very much. The wording of the contract is important. Can I throw in, Victor, another avalanche of questions that are coming your way? A very emotive one here from Michelle. She says, my company has just effected compulsory leave for all staff without consultation by way of a staff circular. If I don't have enough leave days, I essentially owe the company and will pay them in retrospect during the remainder of the year. How legal is this? I feel it's very unfair. That's Michelle. Okay, did you get that, Victor?
Yeah.
Okay, and then Lee Ruizi says, what is the status of people who would have been issued with contracts of employment that were due to commence on 1 April? Do the duties and rights that flow from this agreement still subsist? What is the status of people who would have been issued with contracts of employment that were due to commence on 1 April? Do the duties and rights that flow from this agreement still subsist. And then, oh, Charmaine has got questions flowing. Charmaine Bosch, but Charmaine, allow me to give others a chance. I will come back to you though. Just and then from Paul Nyausaru, he says, can employers do the Zuva? Zuva is in the company case, the Zuva case way of laying off employees hiding behind the coronavirus-induced lockdown. Can employers do the Zuva case way of laying off employees hiding behind the coronavirus-induced lockdown? And then another question from Kudakwashe Manjonjo. Kudakwashe Manjonjo says, can remuneration be supported by the social cash transfer program or the other social protections? Did we get that, Victor?
The last one, please.
The last one is, can remuneration be supported by the social cash transfer program or there are other social protections? This is from Kuda Kwashe Manjonjo.
Okay. So
And
just
then
to take them in.
After this, we will be going. We are now on the 9-minute mark. We've got about 9 minutes for our session today. So after this, we'll take the last, squeeze in the last questions, and then we can all wrap up with a word of closing, and then yeah, call it a day.
Okay. Thank you, Maimba. So regarding to compulsory leave without consultation, I think what we're going to see is this. Because many companies, because we only got 48 hours notice for lockdown in the evening of a Friday, leaving a Saturday and a Sunday and going into lockdown on a Monday morning. There was no time for consultation, but decisions had to be taken. I think what we're going to see is a lot of consultation which will seek to have issues ratified when we resume. That's my suspicion. But but I'm also aware that a lot of organizations have actually communicated to say, we will be coming to you to seek ratification for this. So that would be my answer so far as that goes. So the status of people whose contracts were starting on the 1st of April, again, I think it's important. It's an unusual circumstance. You will not find precedent on this one in our jurisdiction. So it's important to go back to dialogue. The parties still have to come back together and say, these are our circumstances. How do we treat our peculiar contracts? I think we're back to social dialogue. So the next one, when the gentleman refers to the Zuva case, I assume he is referring to termination on notice without compensation for loss of employment. Well, you definitely cannot do that now, if that's what you are referring to, because remember, the amendment from 2015, which followed barely a month after the Zuva judgment, it specifically outlawed that and made provision for compensation for loss of employment, even in cases where the employer attempts to terminate employment on the basis of notice without without going through retrenchment. And lastly, I'm not aware of any social protection that addresses specifically the COVID circumstances. I think the only new thing that I'm aware of is the ministry has actually caused NASA to accept sickness owing to COVID to be covered as a payable sickness, as a compensable sickness in terms of the National Social Security Act and the protection scheme created under it. I'll defer to the others so far as the other issues that I may have overlooked.
Well, thank you very much. I'm going to go through the last wave of questions, just squeeze them in there. Last waves of Mark Mocho Butao, who is a doctor. I know him because he's my young brother, this one. Thank you, Mark, for coming through. As an employee providing essential service, but I feel that my employer is not providing adequate prevention measures, what options do I have? I know he's a doctor, he's a medical doctor, he's an essential service. Again, Mark, thank you very much. I know that you guys are on the front line. And his question is, as an employee providing essential service, but I feel that my employer is not providing adequate prevention measures. What options do I have? And then Frank Marara says, if we are on a partial exemption and a portion of staff is working and the rest of staff is not working, should we pay the two groups full salary, or the issue will be settled by leave forms? That's Frank. Others are working, some are not working, same company. Do we get the same remuneration? Is Frank Marara's question. And then Lee Ruizi says, obviously there are going to be a lot of restructuring of business models and plans. What is the position of non-essential professionals whose companies might not find useful post-COVID-19? How do companies avoid arbitrary retrenchment? That's from Lee Maruizi. And the last question, again, I'll go to Charmaine. For fixed term contracts, do we still need to pay salaries when there's no income being generated? For example, contracts that expire in June. This is our last wave of questions, and then we're going to wrap this conversation.
Wow.
And as you're putting your thoughts together, Victor, unless if you're ready.
Please go, Maimba, and then I'll come after you.
Okay, cool. So again, allow me to say thank you to each one of you for plugging in. This is the first in a series. It's a three-part series, and we're really excited to be hosting this webinar. We're going to be hosting these webinars in different segments, and we're going to be letting you know. Allow me to thank our partners. Thank you to, of course, to the hosting partner, Dr. Machalaga, the CEO of Primson Management Services. Primson Management Services is a consulting firm based in Zimbabwe, Zambia, and Botswana, and we offer a wide range of consulting services, including gender audits, evaluations, SDG alignments, and research. We're all over Zimbabwe, Zambia. We've got 20 years of experience working in multinational companies across the world, and we're very excited to be hosting this webinar. And of course, Distinctive Consultancy Services, which started operations in 2008 and is a business consultancy organization offering specialized solutions in strategy, human resources, and organizational development. And EduDynamics is a subsidiary of DCS and specializes in human resources development and educational solutions. And of course, Cutting Edge Solutions, which is my company. We are a team building consultancy where we build teams, great teams, amazing teams from experiential learning. These are our partners. Thank you so much. And now, Victor, you want to wrap this up?
Thank you, Maimba. Let's start with the last question. The treatment of the fixed term contracts is not different from others. We have an obligation to go by the terms of our contracts, and if we are going to walk away from those obligations in those contracts, we need both parties to follow due process. That's all I can say. There is no difference really to say this is fixed term, this is what. Our obligation is per contract and is per the Labor Act, and we need to observe that. That's for both parties. Then essential service. This is a minefield, Maimba, because this is a life and death thing, and we've seen doctors going down. I mean, more than 50 in Italy, if you remember, and so it's a very serious issue. But I would like to say each case will obviously depend on its own merits. That's fundamental. But one needs to say, one of the few circumstances in the provisions of the Act in which employees can actually take collective job action or withdraw labor without even giving the statutory 14 days notice is where there is immediate harm to their health or to their life or to limb. So that's certainly in the law, no doubt about it. But like I say, a lot will depend on the facts of each case. And you know how when you walk away, you're walking away from sick people who can't help themselves, etc. So those are the difficulties that go with the decision. The second question, I think this is a matter for internal communication again. There is also arising there the matter of fairness and equity. You have a guy that is risking going into public transport to get to the workplace and they're at work, and you have a guy that is sitting at home. Are you going to treat them the same? It would appear to me that that organization has two options: either not to pay the guys who are not coming to work, or pay them a lower rate compared to the guys that are coming to work, but maybe more preferably to pay some allowance, some kind of risk allowance, one would think, for those that have taken the trouble to come to work over and above their normal remuneration. So,
Okay.
but again, dialogue. Arbitrary retrenchments. Well, there's due process. If you're going to retrench, you have to follow due process. Is provided for in the act. As to whether arbitrary or not, I couldn't be too sure. Yeah. So that would be my input, Maimba. Thank you very much.
Well, thank you very much, Dr. Kanyenze. Your closing word, please.
Yeah, I just wanted to add that with respect to the issue of safety, at the TNF meeting on Thursday, this issue was raised, and it was agreed that the normal system that is already in place, where NASA has got occupational safety and health officers, should be alerted. So if you suspect that you are working under very unsecure circumstances, you should actually whistleblow. You should raise the issue with the relevant authorities, so that the inspectors can come and investigate. So that's one issue. So we are under extraordinary circumstances, and the issue is no longer an employer's obligation vis-a-vis responsibilities of workers, but the way we can be creative as a nation. That's why you see countries that have become much more creative in coming up with solidarity funds, coming up with emergency relief funds, coming up with a lot of support to the employers, enterprises, so that they can stabilize the entities and also employment. I think those will basically be able to deal with the crisis better than where we haven't been creative. So we need really to be creative. So what I'm going to say is, the parting short, is that we need to reactivate our platforms for social dialogue, be they at TNF level, NEC level, and also shop floor level. So dialogue to discuss these issues, and creative ways of dealing with these issues will help us navigate this very treacherous terrain with the minimal sort of adverse impacts.
Thank you, Dr. Kanyenze. Dialogue, social dialogue will obviously help us a lot. And Rose, your parting shot?
I think Godfrey took some of them. I had mine here as communication. You will notice that organizations that always had communication channels open with their employees, some of the things we are battling with, or some of the questions we are getting here, they solved them already because they had dialogue. So for instance, the issue of whether or not people should be paid, the ones at work, the ones at home, a lot of organizations have paid 100% those who are going to work plus a risk allowance, and then 50% to those who are at home. But why that has happened, and it has happened well, is because the communication channels were kept open. So I think as the HR practitioners or as employers, a lot of the communication channels that have been put into the Labour Act itself, your works councils, etc., I think some of them, we have looked at them with contempt as employers and not really use them or utilize them. It's at a time like this that we realize the importance of such communication channels, and I'm hoping that even as we are in the lockdown, we should start putting together strategies of how best we can communicate, because if you listened to Victor's answers, most of them, they kept going back to social dialogue. It's difficult for an organization in the middle of a pandemic to now start wanting to have social dialogue, something that we should have done. But this is a good lesson for employers, and I hope going forward, we will communicate.
Communicate, and communicate. Thank you very much, Rose. Again, allow me to say thank you to Victor Nkomo, who was our lead presenter and is a legal expert, legal practitioner with over 10 years experience as a magistrate and over 20 years experience as human resources practitioner. He's past chairman of MCO's Labour Committee and past president of IPMZ. He also loves blogging on issues of labor law matters in his free time. Please, you can look for all these guys on their handles. And of course, the next one, like I said, you have to plug into all three. So Victor started with the legal side. Victor, it's a baton relay, really. And then Victor is going to pass on the baton to Mrs. Rose Namo. She's an HR expert. She's going to be our next presenter. I'll give you a bio, and on the 22nd when she comes through. She's an HR consultant, and she's going to take us through our next presentation on the 22nd. And then, of course, Dr. Godfrey Kanyenze, a labor expert, will be on Friday on the 24th. So I hope you guys have registered. Make sure that you register for each one of these sessions. And thank you for those that came through today. And we look forward to seeing you on the 22nd. Please send us your comments. Did you find this helpful at all? What would you like us to better? We always believe in, Kaizen, improving ourselves, being better at every opportunity. So speak to us at Crimson Management Services, and we'll really, really love that to do. As we close, and of course, you can also download the presentation from Victor from our website, and have that and share that with your colleagues. Again, let me say thank you to Dr. Machalaga, the CEO of Crimson Management Services. Thank you to Simukai, the back. These are guys that are called behind the scenes. Now, this is our credit section. Simukai, thank you. Great work, guys. And Itai, Tafire Nyika, behind the scenes, thank you. Great work. And of course, Farai Muzondiwa, thank you so much. We appreciate you. Thank you so much. And to everybody else, take care of yourselves. Wash your hands. Make sure you wash your hands thoroughly, everywhere. All right, don't touch your mouth, don't touch your nose, don't touch your eyes, don't touch your face. Stay safe in your homes, social distancing. Check on your loved ones. Go call your aunties, your grandfathers, everybody in the rural village. Phone your loved ones, find out how they're doing. Peace and love. Share the little that you have. It's a tough time the next 2 weeks. God bless, God keep you. My name is Maimba, spelled M-A-I-M-B-A. Thanks, everybody.
Thank you.
Thank you.